Hi, I'm the business guy. I'm the CEO of Lawyers Limited, the nation's largest asset protection firm. What is an asset protection trust? How does it work? And what kind will best protect your assets? When it comes to asset protection trusts, there are two types, domestic and offshore. So what's better? And we'll answer that question, but first, if you could help me out by clicking the like button below so YouTube promotes this video, I'd really appreciate it. And if you haven't already, please click the subscribe button below so that when more videos come out like this one, you'll be up to date right away. Domestic trusts. A domestic asset protection trust is a trust formed in the U.S. under U.S. laws and has one or more U.S. trustees. It is drafted to shield items of value from being seized in lawsuits. In recent times, some states such as Nevada, Delaware, Wyoming, and Alaska have adopted statutes allowing one or more people to form a trust called a settlor with spendthrift provisions which are intended to keep assets from creditors. Unlike traditional statutes, the settlor can also be a beneficiary of the trust. That is, the settlor can enjoy the proceeds while at the same time keeping trust assets from his legal enemies. So in this video, we'll discuss these tools and provide you with tips, information, and hints to improve your chances of surviving a full frontal attack by an aggressive litigant. Offshore trusts. An offshore asset protection trust is formed under the laws of a foreign country to the trust settlor. Again, the settlor is the one who creates the trust. If you call us to create a trust, that'd be you. The settlor then transfers property into the trust and the trustee manages the trust. In our case, the trustee is our offshore law firm. Now, offshore trusts came into existence in the early 1900s as high net worth individuals used offshore trusts for asset protection from lawsuits and tax efficiency. Such trusts for United States persons are tax neutral under current statutes. However, they still provide powerful asset protection. People in the UK utilize trust in the Channel Islands. People in the US preferred coconuts and mangoes over crumpets and tea, so they set up their trust in the Bahamas. Today, more people use offshore trusts than ever before. Jurisdictions with the strongest asset protection include the Cook Islands in the Pacific and Nevis in the Caribbean, which have far surpassed Bahamas and the Channel Islands. The main benefits people seek today: asset protection from lawsuits. Local courts have jurisdiction over local assets. However, with offshore trusts, our trustee law firm is at the helm. Thus, courts in the US, UK, Australia, Canada, etc. do not have jurisdiction over the Cook Islands or Nevis. So the court orders to turn over your trust assets to your legal enemies will fall on deaf ears. Well, on second thought, their hearing is pretty good, but it's kind of like your wife asking you to take out the trash during the Super Bowl. That kind of deaf ears. So if you're serious about protecting your assets from lawsuits, give us a call and speak with one of our attorneys or consultants at the number below, or fill out a free consultation form at assetprotectionplanners.com. Asset protection trust benefits. Here's the bottom line. We see the following features in the trust laws of the states we mentioned above. Asset protection. You can settle the trust, that is, have it created and put money and property into it, and can be the beneficiary of the trust. At the same time, it can keep trust assets away from creditors. Thus, we call it a self-settled trust because you create it and can benefit from it. It has spendthrift provisions. This means there are provisions to keep trust assets out of the hands of creditors. States without these special laws do not allow these types of trust to shield your assets from creditors. Second, shorter time for creditor challenge. The creditors don't have much time to challenge the transfer of assets into the trust compared to other states. So there is a relatively short statute of limitations on fraudulent transfer. In Nevada, for example, you can form a trust, put assets into it, and then 2 years later, those assets are theoretically safe from lawsuits. If you transfer assets into a Nevada asset protection trust and properly publish the event, you can reduce that time frame to 6 months. In many other states, you have to wait 6 to 15 years to file a claim. Next, higher barriers to creditors. Laws make it more difficult for a creditor to try to convince a courtroom that you put the money into the trust to keep it from creditors. Okay, now let's compare domestic to offshore trusts. For asset protection purposes, how do domestic and offshore trusts compare, and what are the advantages and disadvantages of each? Now, we established both domestic and offshore trusts as well as corporations and LLCs, both local and foreign. So we don't have an axe to grind, and most importantly, we can back it up with facts that are so compelling that we have a just cause to state a strong opinion. Bottom line, the offshore asset protection wins hands down. And here's why. Here are the top 10 reasons why the international structure wins the domestic versus offshore asset protection trust battle. Number one, Offshore trusts are not subject to local court orders. In a civil lawsuit, suppose a judge orders a U.S. trustee to release funds or to be thrown in jail for contempt of court. Can you guess what the trustee is going to do? The offshore trustee, on the other hand, can simply ignore U.S. court orders because he's not bound by them. Number two, the domestic trustee's assets are at risk. We have seen U.S. plaintiffs sue domestic trustees in civil lawsuits. When the trustee has the choice of coughing up your assets or his own, you already know which one he'll choose. Moreover, the domestic trustee is subject to scare tactics. Suppose, on the other hand, the plaintiff's attorney implies threats of or actually succeeds in getting the government involved. Such threats terrify the trustee with racketeering or money laundering charges for failure to release the funds. In that instance, the domestic trustee is worthless. This drawback in itself is enough to kill the asset protection of a domestic trust. There may be a statute of limitations on fraudulent transfer, but there's no statute of limitations on trustee terror. Number four, offshore trust jurisdictions can ignore U.S. judgments. In the Cook Islands, Belize, and Nevis, to name a few, the courts do not acknowledge U.S. judgments. So the creditor would have to start afresh and file a new lawsuits from the very beginning. This tremendously high expense and time-consuming undertaking is about enough to deter even the most resolute of plaintiffs from pursuing an offshore trust. To top it off, even after a die-hard attacker has been exhausted from the foreign battle, you can re-domicile the trust and change it from a Cook Islands trust to a Belize trust and then to a Nevis trust. In each case, your opponent would have to start from scratch. Number five, U.S. states fully recognize out-of-state judgments. In contrast to the above, suppose your enemy gets a judgment against you in any U.S. state. The law requires every other state to recognize it. That means a creditor can move his judgment to any state and start seizing assets without having to file another lawsuit. And this is very easy and inexpensive for the creditor. In fact, collection agents will often do it for free to get a piece of the action when they collect from you. Number six, U.S. judges consistently rule according to their own state's laws. You get a judgment against yourself in California, but have assets in a Nevada trust. Do you honestly think the California judge is going to apply Nevada law to property located in California? Good luck. The creditor gets your assets and liquidates them, and then it's up to you to file an appeal to get them back. Ironically, we have seen plaintiffs protect seized and liquidated assets from appeal by using offshore trusts, something that you could have done to keep them out of his hands in the first place. Number seven, federal courts can ignore state laws. Federal courts are not essentially bound by state law. This is even more concerning when you take into account that the big hairy cases are usually the federal lawsuits. Number eight, asset seizure without due process. It is even more daunting when a federal agency gets involved. Often the policy is seize now and ask questions later. You may be surprised how many times we have seen this happen. Time and time again, we have seen an administrative agency suddenly strip a would-be client bare and defenseless before they can even file a lawsuit. That being said, we do not knowingly protect assets from government agencies. Number nine, privacy is thrown out the window. U.S. trustees are drug into depositions on a routine basis. The local trustee of a domestic asset protection trust is subject to subpoena and must cough up documents that may be used against you. Each state applies its own laws, and the federal courts apply their own laws. And a domestic trustee must comply regardless of the state in which he resides. The state in which one forms the trust doesn't matter. The trustee of an offshore asset protection trust, on the other hand, can simply discard and ignore deposition and subpoena requests. And finally, number 10, offshore bank accounts. People often shelter offshore bank accounts inside of offshore trusts, outside of the reach of U.S. court. Even if a domestic asset protection had assets in a foreign bank, the courts would compel the domestic trustee to bring them back. Not so with a foreign trustee. Okay, are offshore banks safe? Every year, a well-respected publication called Global Finance that I read yearly rates the world's 50 safest banks. In the most recent rankings as of this video, 40% of the safest banks are in Europe. The majority of the rest of them are in Asia and Australia. Only 4 were located in the United States. The highest ranked bank was only number 35 on the list. In other words, there are 34 banks in the world that are safer than the very safest U.S. bank. The other U.S. banks on the list were number 44, 46, and 47, and all of them are tiny farming banks. So those who ask, are offshore banks safe, should be asking, are U.S. banks safe? A whopping 547 U.S. banks have failed in the past 15 years. A Forbes article recently questioned whether or not the FDIC, a private corporation, was on the brink of bankruptcy. How much comfort would it give you that the FDIC is backed by the full faith and credit of the most in-debt country in the world? Okay, when to use a domestic asset protection trust. So are all domestic asset protection trusts bad? We're not saying they're all bad. We're just saying that there's a much better choice, especially for liquid assets. So when would you use a domestic trust? You stand a fair chance when you meet all of the following criterion at once. Number one, you live in Alaska, Nevada, Delaware, Wyoming, or other state that offers them. These states all recognize self-settled domestic asset protection trusts. Incidentally, if you do live in one of these states, we would typically choose Nevada or Wyoming trusts since they have some of the smallest windows of time for creditors to challenge transfers into the trust. And then pray that the judge uses Nevada or Wyoming statutes. Number two, you have all of your assets in one or more of the above states. Number three, you think you can avoid a federal lawsuit. Number four, the potential at-risk assets have been placed into the trust before the problems arrive. In Nevada, for example, the creditor must file a claim within 2 years after somebody transfers assets into the trust or 6 months before your creditor knew or should have known that you transferred assets into the trust. If you don't meet all of the above at the same time, then use an offshore trust because the domestic asset protection trust probably isn't going to do the trick. Getting comfortable with offshore. Alternatively, there are some who have not yet busted out of the U.S. cocoon. They have the isolationist notion that U.S. equals safe and everywhere else equals scary, despite overwhelming evidence to the contrary. For those people stuck in that mode, a domestic asset protection trust is far better than nothing. Again, we're not saying to never use the domestic option, but we're making you aware that there are much stronger choices. For what it's worth, this ain't yo mama's America anymore. Things have changed. There were more U.S. bank failures during the Great Recession than there have been in our entire lifetimes. The euro fluctuates and is often stronger than the dollar. There's a great big hole in our financial dike, and the Great China Sea is located downstream. Things aren't safe here anymore. Hype versus results. Now keep in mind that different promoters tout their magic formulae. They will search long and hard to find instances where the alternatives to what they offer got caught in the thickets. Fortunately, we don't have that issue because we have the ability to offer a full banquet of various legal tools. So for us, it's just the facts, ma'am. We have literally formed thousands of domestic and foreign asset protection trusts, living trust, children's trust, land trust, corporations, LLCs, and many more, thus have no self-serving bias. Plain vanilla living trust, title holding trust, and land trust do not provide asset protection. Domestic asset protection trusts can help shield assets in certain circumstances, especially if established in one of the aforementioned states that have recently put some muscle into their laws. Nothing we have seen beats the offshore asset protection trust. It simply works. In fact, we have more information about specific countries in a video entitled Best Offshore Trust Jurisdictions. And by the way, I might as well mention this again. As a responsible company, it is our policy, as we said, to not intentionally set up trusts to protect assets from the U.S. government, and we do not tout trusts for tax avoidance. These trusts are generally tax neutral. Conclusion. So what's the bottom line? It is that the offshore asset protection trust simply provides better asset protection than the domestic alternative. So when you're climbing the ladder to asset protection success, going from nothing to a domestic trust takes you several steps up the ladder. Something's better than nothing, but properly using the offshore asset protection trust takes you straight to the top rung. The advent of the domestic trust is a testament to how well the offshore trust has fared. U.S. states are jumping on the bandwagon. So buyer beware. If you are about to leap into one of the two lifeboats, we would suggest that you not choose the one with 10 holes in it. Though the offshore trust has rare instances where rogue judges have tried to brew up a storm, we know of no cases in modern trust case law where a properly structured Cook Islands or Nevis Trust has not protected trust assets. For years, it has proven to be the most weatherproof option that we have seen. Want more information about the Asset Protection Trust? Give us a call at 1-954-400-1050 or visit assetprotectionplanners.com. Please like, subscribe, and share this video with others. See you next time. This is The Business Guy.